So when I say over and over again with these cases, this next one is a very sensitive case. It caught the headlines in a massive way, and sometimes that's a good thing, but sometimes it can mean very little in terms of what happens in the actual alleyways of the court. And in this segment, we're going to look at how the National Prosecution Authority have made the decision not to prosecute the high-profile Cwecwe rape case. Now, it's a ruling that's left many South Africans absolutely shocked, questioning the fairness of our justice system. It's a correctional decision that has sparked widespread public outrage and debate, exposing deep frustration on how sexual violence cases are handled in the country. So I think it's very important for us to also understand that, law is not emotion. Law is law. This is how they function. You have to mathematically link the issues that you've been given, that you hand over to the judge. And just because we have a Justice for Cwecwe hashtag doesn't necessarily mean that you're going to have a Justice for Cwecwe outcome in the legal proceedings. So let's get an understanding of that, and then we'll address some of the complexities that prosecutors face when balancing the rights of the accused and the need to support survivors, and then why in this specific case the NPA's decision not to prosecute in the Cwecwe case. Legal Analyst Nthabiseng Dubazana is here in studio with us. Did you know that was coming? Does it happen every day to you?
Yes. I've been called Dubazani, Dumbazani, like Dubazana. I was bad.
And you know what? I see it. I think I just left the second A, and then it all became a mess. So Nthabiseng Dubazana, thank you very much for joining us.
Thank you so much for having me.
And having a sense of humor and not getting angry with me for butchering your name.
Not at all.
You know, the NPA story has been big on our show because we spoke about the Omotose case a little bit earlier on, and now we're talking about this. Could you maybe explain the legal principles or the criteria that guide the NPA's decision to prosecute or not prosecute, especially in a case like Cwecwe's?
So in cases such as this, what we rely, or rather what the state would rely on, is one, the elements of each crime, of the crime, have to be met. So in this particular crime, it would be obviously the intention of the accused, the unlawfulness of the act, and then the act itself. So over and above that, what we also rely on is the linking, the chain evidence that needs to be followed in respect of whom the accused person is in this particular case. So in rape cases, what happens is that if the victim, let's say it happened today, and then they're able to go to the police station today or tomorrow, then they're able to have a J88 filled in. So a J88 is a form that the police use, that you go and take to the doctor, so the doctor can fill in whatever wounds or bruises, whatever that is happening with you in that particular situation. And then they have the opportunity to extract any semen that would have been left by the perpetrator, because semen lasts 72 hours in the body of a woman. Sure. So if you go beyond after 72 hours, you're making the job of the police very hard, because if you're saying that Nthabiseng is the one that did it, and then we are able to extract semen from you, and we're able to extract DNA from Nthabiseng, then we can match it and we can confirm without a shadow of a doubt that Nthabiseng is the perpetrator. But without that, which is what happened in the Cwecwe case, unfortunately, there is no one that is exactly pointed out, and also over and above that, there is no link that is caused between, or that is done between all the accused persons that were labeled and any DNA. And I'm sure when we look at the J88, the doctor did not see any bruisings on the vaginal area and whatnot, because there's healing that has already happened. So as such, it is very, very difficult for the state to prove its case in that situation.
I mean, that is very heavy, because it took this little girl quite a while to tell her parents. So it's not as if somebody at home knew and just didn't do the right thing, I think you find often with very small children that, I mean, you've got to be watching all the time. They're not necessarily going to tell you the same day that something had happened. And so, okay, so we've spoken about gathering and presenting evidence in sexual violence cases. But then what is the norm? Is this why we're seeing so many rape cases, sexual violence cases, child abuse cases being thrown out because of this inability to go the very first moment that you can to get the police and the doctors to check you out?
Unfortunately, yes. Because as defense attorneys, our job is to see whether or not the state can prove its case beyond a reasonable doubt. My job is not to assist you as the NPA to prove your case. So I'm going to sit back and watch and see what's happening. And when I look at the docket once it's officially given to me, I'm going to make representations to the DPP or the NDPP and say, listen, based on the docket, you are missing this, that, and the other based on the elements of this particular crime. If you proceed in prosecuting my client, we will seek to take this matter for civil litigation for wrongful prosecution. So you have to be very clear as the state when you look at the docket that you have a good chance of success should you proceed in prosecuting whatever case you have in front of you.
But then in a case like this, you would know going in that you don't necessarily have a strong case.
Yep. And you have to communicate it to the complainant because at the end of the day, as the NPA, the complainant is basically your client and you are the attorney for the complainant. And it's not news that are going to be very easily accepted because, it's a heavy situation. But if there's nothing in the docket that can prove anything going forward, then I can't do anything because if I do proceed, I'm opening up the state to litigation, which will sometimes, if the judge sees fit, says that even the prosecutor must be held liable for continuing with this case, knowing full well that there was nothing. Yeah.
That is unbelievably sad. A guest we often have on air, Dr. Shahida Omar from the Teddy Bear Clinic, said, we are shocked. This can't be happening. It's not possible. And what comes to mind, she says, after 35 years of working in the field, is disclosure is a process. So it's important to understand some children may not disclose purposefully after the traumatic incident. It may take weeks, months, or even years. Some children may not even disclose at all. What's the messaging here? How then does protecting the survivor and upholding the legal process, how do you balance those two?
I don't know if there is a real balance, to be honest, Pabi, because how do you do it? I mean, it is very true that we've seen cases that are only being litigated 20 plus years later, and the only evidence is my word against his or his word against mine. And as such, now the court has to rely on circumstantial evidence and all of that. Sometimes there's a conviction, other times there isn't. Rape cases, unfortunately, are very physical evidence oriented versus circumstantial evidence because let's say it's murder, for example. Nobody really has to find the body, but the circumstances that led to the disappearance of Nthabiseng and now the body being found, we can link this particular person to the last seen venue of Nthabiseng. Maybe we can convict the perpetrator. But with rape cases, that's the downside. And sadly, child witnesses are not the greatest witnesses because under cross-examination, they crumble. And it's not like a defense attorney is going to go easy on a child just because it's a child, So it is very difficult for the state to say, if we proceed, there's a chance that the court might have empathy for the child. No, because the court has to listen to the facts as they are. And if the child contradicts herself while on the stand, then it becomes a bit of a problem.
It feels as if there should be then another way to do it, right? So we know that JA8 form is so important. And I always ask my legal experts, if you, God forbid, are raped or sexually assaulted, must you go to the hospital first or must you go to the police station first?
I always say go to the police station first.
Okay.
Tell them that this is the situation. May you have a J88. That way you go with the J88 to the hospital or to your doctor,
Okay.
and then they fill that in. They do all the tests. They write all the bruises, the injuries,
Yes.
everything that is there. You can go make your statement later.
Okay.
It's fine.
Okay.
But make sure that the J88 is completed, it is done, it is dusted. Because that first initial evidence kit is the one that's going to help the prosecution be able to prove its case. Because if you go 72 hours later, already the semen is gone. I can't link the perpetrator.
Yeah.
After 5 days, your bruises are gone. And another thing that is not very well known when we get training in sexual offenses, the vaginal area doesn't get only bruised if it's a violent crime. Even when it is your partner and you're having fun and you're loving it, it is going to get bruised. So those are the kinds of questions that you're going to expect when you're being cross-examined to say, no, man, just because you were bruised doesn't mean that you were raped.
Yeah.
So these are the things that you need your doctor to be sure that they fill in these things in the J88, and your emotional state is recorded in the J88. It's very important because they put your emotional state there. How we are 72 hours later or 5 days later, you have calmed down a bit. It may be sad, but it's not as bad as it would have been on the day of the incident itself.
Sure. It just makes me think of so many people in so many scenarios around the country, right? It would take however many taxis to get to a police station, then to get to. So it's, and after this horrific thing has happened to you, it would be very difficult. And I'm just reading more about Cwecwe and this particular case because, people who've worked with child abuse and the child abuse medical clinic have learned that 80 to 90% cases after foreign examination it holds no conclusive physical evidence, particularly because we're talking about small children who may tell you a month later, 6 months later, or when they suddenly turn 29. So I wonder what reforms you could recommend to enhance the effectiveness and the fairness of the NPA's prosecutorial discretion, especially with child molestation cases.
It will have to be a development of the law, and to what extent, I'm not sure, because remember, unfortunately, in the legal sphere, we are creatures of instruction.
Yeah.
So if we don't get an instruction, if a complaint doesn't come to the NPA can't act. And when the MPA eventually does get a complaint and it's months later, there is no physical evidence for it to really act. So what do we do? Does it start in the home, wherein mom, dad, guardian, whoever is responsible for the child? Is it a situation where you start teaching children about who can touch you where, why they shouldn't touch you there, all of those things, and encouraging children to speak up earlier? Because sometimes you may find that the child has never been exposed to these conversations and they wouldn't know where to start when they start telling their parents or their guardians. So teddy bears, institutions like the Teddy Bear Clinic, they were actually brought in to assist with situations such as this. But unfortunately, one, they are overwhelmed. There's a lot that is happening. There's maintenance cases, there's divorce cases, there's custody cases, all these things. And then now there's also sexual assault that is included there. But even police stations, they are trying to have places where complainants can go and give their story in a safe and closed environment, but it doesn't mean that they come on the day that the incident happens. So unfortunately, the onus, it rests on you, the person who's suffering, to go and start the process, and then the rest we can try and see how best you can be assisted.
Sure. I'm just thinking of the 7-year-old, and the onus is upon them, and they already have been so violated. There's no simple answer. There's no easy answer,
No.
and that I understand. But I think that the more that we talk about it, and the more that, for example, we know to go to the police first, we know what the process may be, and we know what should be noted, would give the MPA a better chance once we go to court. And exactly that. Teach your children what's good touch, what's bad touch. I've told our power listeners what I've done with my child. It's a bit extreme, but rather go too far than go too little. I said, if anyone in any of these toilets, or your coach or your sensei or anyone, you swear the biggest, worst swear word in your life, especially if it's in public, and say, do not touch and I put the real word in there, penis.
Yeah.
Do not, someone's, and scream it out. And so I think the people from downstairs think that something's happening in my house because we practice it on a regular basis. But rather have them go too far than not. And that thing, which is very difficult for a lot of us as parents, and I'm sure the shame that they feel and confusion that they feel as little ones, it's also scary to come and say what happened on the day.
Yeah, that's very true.
Well, we'll leave it there for now. Legal Analyst Nthabiseng Dubazana, thank you very much for joining us this afternoon.